You're listening to God, Law, and Liberty with David Fowler and Gary Humble. We're putting culture on a collision course with the truth.
Welcome to another episode of God, Law, and Liberty. I'm Gary.
And I'm David.
And, as we start today, I just want to say, go Navy. Today, my boys and I got to see the Blue Angels fly over Franklin, here in Franklin, Tennessee. And that was awesome. It really was.
Well, that is cool. Cool. I thought you were talking, there was some celebrity. No, a friend of ours lives in Seattle, just named her baby Navy. And I thought, well, that's cool. You must know Desiree.
No, I went to Bible college in Pensacola, where that's where the Blue Angels were stationed. Yeah. And so I've seen them before. I've seen them fly right over Pensacola Beach, which was pretty incredible. But got to see them today here in Franklin. So that was pretty great. I really appreciate those guys. They've been doing a tour around the U.S. and flying over, and that's pretty neat. So anyway, go Navy, go USA. Yeah. That was pretty cool. All
right, cool. Yeah.
So today, I think we're getting into this issue a little bit. We've mentioned this phrase before, substantive due process. It's kind of hard to say.
Yeah.
Substantive. But we've had some cases happen over this last couple of weeks where, essentially the idea is that the court has sort of redefined what due process is. We have the right to due process according to the Fifth Amendment, and then of course the 14th Amendment, and which really means process, right?
Yeah.
But as we've redefined several words in the Constitution here in the courts. They've redefined what due process means to get a little bit more levity, I guess, whenever they want to do so. So I know there's a couple cases you want to bring up, and looking forward to dig into that. The one I first saw when I emailed you about it was this Sixth Circuit case.
Right.
I think it was in Detroit, having to do with the school system, and essentially the Sixth Circuit has sort of expanded now using substantive due process a right to education per the Constitution, and sort of going down the path of federalizing education, which of course is pretty dangerous, I would think, but I'll let you speak to that a bit.
Yeah, well, as you alluded, there are a couple of other things I want to talk about today too, if we have time, all of which I think we could put under the rubric of what I would call rogue judges. Judges that are going outside the lines. Not calling balls and strikes anymore, but redefining the rules of the game, throwing the balls, calling them strikes and swinging at them, and deciding how to field them. And at some point, legislative bodies, either congressmen or state legislators when they're state judges, are going to have to take some action against judges that show they do not understand the nature of their role in our three branches of government. And if that doesn't happen, then I think this feeling that many have, I've heard it over the years, what difference does my vote matter? It doesn't matter. It doesn't matter what, it just doesn't matter.
Because the court's going to decide what the law is apparently anyway.
Sometimes they feel like the legislature doesn't care what they want to do, but the legislature says, well, my hands are tied by some judge. And the reality is you have a lot more authority over the judicial branch than you think you do. And it really serves everybody's interest. I've said this before. Legislators sometimes don't want to have to do what they need to do. So somebody goes to court, and some rogue federal judge or state judge, drunk with the thought of power of running a school system or whatever it is, says, okay, well, I'm going to mandate this. And then the legislature wrings their hands and complains that, well, I have to vote for this pay raise. I have to vote for this tax increase because the federal judge or the state judge is making me do this or that. And, it's all a shame. And it's kind of like, well, then why don't you impeach that judge? Why don't you remove that judge from office? Why don't you do what you need to do with the powers you have to limit the judicial powers to the judicial powers? Don't let them become legislative bodies. And unfortunately, more and more things are going to continue to be decided by judges because legislators don't want to do the right thing. They're scared of doing the right thing. Then get somebody else to do it for them. And as I mentioned, 3 or 4 years ago, I brought a bill to a lawyer member of the state Senate that simply said that in our statutes, the words mother, father, husband, and wife would be given their normal, natural, ordinary meaning. Now, I knew that was going to be controversial.
That's a crazy bill, David.
It is a crazy bill to say, Susie will never be a father. Just not going to happen, And this legislator, evangelical Christian, lawyer, supposedly conservative, runs on that kind of ticket, Republican in our state legislature, in our state Senate, said, well, boy, that'll be sure controversial. He said, I don't know if anybody up here would want to handle that. Maybe we should just let the judges redefine the words.
And there you go.
Wow. There you go. Just let them do it. So here's what's happened in the city of Detroit.
Why? And why let them do it? Because then we don't have to bring up how I voted come election time. It's just a non-issue because, the court did it.
Yeah, the court did it. Yeah, the court did it. And nothing I can do about that, right? So that's what happened in the city of Detroit. Apparently their school system is terrible, terrible, terrible. And so somebody brought a lawsuit on behalf of the students. They brought an equal protection claim. I thought what was interesting is that there was also a claim that their rights were being violated because of the compulsory school attendance laws, that made them go to schools if they couldn't afford private schools, and the schools were terrible. Now that's kind of an interesting argument. Hey, just repeal your compulsory attendance laws and let me go pick another school. Or, voucher advocates would say, give me some money and let me go find another school.
Which on behalf of the kids and parents, certainly. Yeah. I mean, I'd be making that argument too. I mean, let me get a good education. Don't trap me into this failed system.
Yeah. Yeah, that's right. Don't trap me in here with a compulsory attendance laws and then give me a crappy school. But anyway, the court ultimately turned on this notion you mentioned of substantive due process. Now, that term should sound oxymoronic to everybody. Substantive process. Is a process really substantive? Is something that's substantive really just a process? And here's how I would distinguish the two. We could pass a bill that says something crazy, like nobody can go to restaurants or bars anymore. I mean, imagine such a crazy kind of bill. It says they have to all close.
Well, we don't need a bill for that these days. Our governors and our mayors just go ahead and do that for us. It's all good.
Oh, well, maybe that's not a crazy example. Let me think of another.
They just shut it all down.
Let me think of another crazy example. But anyway, whatever the example is, but let's just say that. Let's just say that we've outlawed the dine-in establishment.
I'm sorry, I can't let that go. That's just interesting. I mean, 3 months ago, that was a crazy example.
It was.
It's not so crazy anymore.
It's not. Yeah, it's not so crazy. But thankfully, the legislature hadn't done it. Just the governor. So anyway, the point is, and I'm being mean there a little bit, but let's say that's the example. So the question is, the bill gets 50 votes in the state House out of 99, and it gets 17 out of 33 in the Senate. Was the process followed? Yeah, it was processed. The process was followed in order for that to become a law. Now the question is, substantively, is it a good law or a bad law? Okay, and then we debate back and forth the merits of that policy under all the environments and circumstances and so on and so forth. So that's what we're talking about, is due process a process where, for example, you have to give notice of what you're going to do. You're going to have a hearing. Okay, there are lots of cases that turn on process. We see those particularly with respect to adoptions, termination of parental rights. We just don't walk into court and, Linda wouldn't go into court and say, David's a terrible dad. Would you terminate rights as a father without me having notice of it, right? I mean, that would be a process thing. The substance would be, is he really a bad dad? Okay. So the court has this case come up that says these really are terrible schools. The test results show that kids can't even read it at any kind of basic level. Many are just illiterate. Now, the question is that a problem for a court to fix? Is there a substantive right to a quality education? And if there is, who is responsible for providing it? Now, you have lots of choices there, potentially. You can say, well, that's really the responsibility of the parents. It's Gary's job to educate his children.
Yeah.
It's not the state's function to educate children.
That's the way I see it,
anyway. The other option is Gary and taxpayers can come together and they could say, well, we need some help. We can't all home educate or whatever else. And so the government comes along and assists the parents. And there's the view that the state just takes over the role of the parents, which is kind of where we are now. And that's done through the legislative process. They enact statutes for hiring teachers, paying money, raising taxes, establish curriculum, so on and so forth. The third alternative is to have a judge decide what constitutes a basic education, how it should be provided, what kind of curriculum should be offered. Do we do phonics? Do we do whole language? What do we do? And the judge rules it. Well, everybody'd say, well, no, that's not a judge's job. That's not a judge's job. But that's what substantive due process allows a judge to do, is to sit here and, in essence, weigh policy considerations. Well, how much does this cost? How much do I get out of it? What methods am I using right? If 3% of the students graduate and can't read, is that okay? Do I double the amount I spend? And if I only get up to 6%, was that worth it? See, all those are policy considerations.
Which require quite a bit of debate and expert testimony and all sorts of things to decide what those policies should and shouldn't be. Legislature goes through quite a process to determine those policies.
Sure. And one of the things I found out in the legislative process is often the answers to those considerations depend upon whether you're in rural school systems or urban or rural school systems. There's just a different, perhaps, family environment, a different kind of environment.
Yeah, it's not a one-size-fits-all deal.
Yeah, it's not one-size-fits-all. And so anyway, what the Sixth Circuit did when these people sued on behalf of the children is they applied this notion of substantive due process. It's a court-created doctrine. You do not find the word substantive due process in the Constitution. And they said that there was a right to an education in the Constitution, which presumably now makes education a government-required function. Okay, if the Constitution requires it, then what are you going to do? You're going to put parents in jail that don't do it? You're going to fine parents? Well, you're going to probably hold the governments responsible for doing it. And but then comes the question: how do I now enforce this right to this basic education? And one of the things that, as I was reading this opinion, I was thinking back. I took a class in law school. I think every student takes it. It's just one of those basic legal classes called remedies. And you have to look at when a court is making a decision, is what powers does a court have by which it can remedy a wrong? And is there a kind of wrong for which the court can give a remedy? Now that may sound sort of circular, but let's say that during this podcast, I say, I really don't like Gary's beard. I think he looks old and fakey or something. And you don't like it. I'm just making that up. It's just crazy thought, like the restaurant thing. So you go to court and you say, Judge, that was just really mean. It's kind of hurt my spirit. The judge says, I don't know how to remedy that, Gary. Did you lose your job over it? Did you lose friends over it? Did you lose, advertising business? Maybe you got an advertising.
Was I injured outside of my feelings?
Yeah, something where I could remedy that, Now, sometimes the court would say, well, I can issue an injunction, and I can say, stop saying that, stop doing that, okay? If I'm a government official and I won't issue you your handgun carry permit, for instance, and you've met all the requirements, but I don't do it because I don't like you, then the judge can mandamus or mandate that I follow the law and fulfill my public duty. It can give me monetary damages and say, oh, gosh, Gary, because he said those things about you on the radio show, you lost all your advertising clients and that cost you $1 million. Okay, they can do that. But how does a court remedy among those things of money, injunctions, or mandamus? How can a court provide a remedy for a failure to educate somebody?
That's a great question.
How to do it. And I will say that one of the things that happened after Brown versus Board of Education, I wasn't really, I was born really when all that stuff was sort of taking place in Arkansas and Alabama, so I don't remember it. But I've read the cases about it, and what had happened is the Supreme Court had said separate is not equal anymore. So that court-made doctrine, separate but equal, is gone. And so now if you have a public school system, if you want to have public schools, you can't segregate anymore. Well, by definition, if you can't segregate, you have to integrate or, do something so that it doesn't look segregated anymore. Well, that set off a whole string of decisions, and some people will remember this, particularly people my age and older, where some of the federal courts started actually imposing taxes. I think it was in the city of St. Louis, Missouri. The court said, well, you've got to integrate, and in order to do that, you're going to have to bus. In order to do that, you're going to have buses. In order to do that, you're going to have more money or whatever it was. And courts literally were ordering cities to impose taxes, and they were going along. And they were saying, now do this and do this. And we've had in the state of Tennessee, when I came into the legislature, our state prison system was under the control and the jurisdiction of a federal judge to make sure that our prison system was running according to the Constitution. And it's fine to say you can't have excessive punishments and excessive bail, but there's nothing that talks in there about, how much space do you have to have in every cell for every individuals, and can they share toilets, or they have to each have their own toilet, and all those kinds of things. And so this is just a crazy thing that the Sixth Circuit did by assuming, in essence, its ability to say, we're going to take control of the city of Detroit's school system.
Now, who gives it the authority to do that?
Who gives it and then how does the court go about doing it? What tools are in the judicial toolbox? Theoretically, they can't lay taxes, right?
Yeah, as the court has neither force nor will, how are they going to enact
Now,
this?
see, you're going back to the founding fathers here, and that's the problem. But anyway,
I'm just learning all the things that you said, David.
Yeah, well, I know, and it's terrible when you get used against you. But that's what. How does the court do this? Now, you may say, well, I'm a homeschool family. Thank God I'm not in that situation. But think about this. If this is a constitutional right in a child to a certain basic level of education, then, as I said, you would think the government is responsible for that.
No, they're looking to regulate it for sure. I mean, in fact, there's this Harvard, since the COVID thing has come out,
sure,
and people are stuck at home schooling their kids, there's this Harvard professor that has come out,
right,
regarding how horrible homeschooling is, and how this is just going to destroy the country, So anyway.
That's right. So what happens if the government in Tennessee says, okay, but we're going to let parents still homeschool, and then some federal judge says to the state, you're denying those children a good education,
their basic
because
rights,
their parents aren't really doing the job well enough, so you have to send them to public school. People better pay attention. This is real stuff.
Yep.
Now, I'm hopeful that that the government will appeal that decision to the whole, what we call an en banc. They'll ask for an en banc hearing in front of the Sixth Circuit. For what that is, the Sixth Circuit actually has a number of judges. I don't remember how many it is.
Yeah, like 12 15, or 15,
18, 20 or something.
Is.
Yeah, something. And normally your case is heard by a panel of 3 judges. And that way, they don't have 12 judges all having to hear one case. 3 hear one, 3, and so they can divide the workload. But you can ask all the judges, would they consider hearing this case again and arguing it orally? And that's called en banc, the whole bank of judges. And I'm hopeful they'll do that, and that the rest of the judges will see that not only should they not be coming up with some right that's made up out of the head of a judge. There's no long-standing history or tradition of a government right to an education. And they'll realize we're inviting the creation of a right that we have no judicial means to enforce or to run. We can't run school systems. We just don't have, that's not what judges do. They don't run school systems. So hopefully this will get fixed, but it just shows, as I said at the top of the podcast, that we have some rogue judges.
Speaking of rogue judges, let's jump into this other example you sent, because I think it's I've never seen anything like it. It's interestingly, Flynn, it has to do with the Michael Flynn case, which is huge right now. It's revelations happening, nationally, and what happened to that guy. But let's talk about what this federal judge had to say about the U.S. District Attorney deciding that he didn't want to move forward with the case. The judge had something to say about it.
Yeah, sure. Yeah. In that case, the Department of Justice said, we're not going to prosecute this case any further. We're not. And we're going to exercise our prosecutorial discretion to not pursue this further. Now, they have to file a pleading under the rules to advise the judge, I'm dismissing the case. And they have to get permission from the judge under the rule to dismiss the case. But when you understand how the procedures work, and we've used this over and over and over, making bad use of wise procedures because we don't understand them. That's right. It doesn't mean that the judge can say, I'm not going to dismiss this and I'm going to make you prosecute this guy. It could be that Michael Flynn would say, no, I don't want this dismissed. I'm going to prove my innocence. I've been on the front page of the newspaper for the last 10 weeks, and I do not want to be dismissed. I want to go to trial. I'm willing to risk it. In that case, the judge might say, okay, he wants to have a trial. What are you going to do to repair his good name or whatever else?
But in that case, someone is bringing an issue before the judge.
That's right. They're bringing it in front of the judge.
Yeah.
And it's the person that's to arguably be harmed that's asking for it to go forward.
Right.
I mean, Flynn's not over here saying, man, I'd really love to be prosecuted. Can y'all keep doing this? This is great. I'm spending money and going broke. This is great. Yeah. No, and so the judge takes it upon himself to appoint special counsel to argue that the Department of Justice should not be allowed to dismiss this case. Now, if you don't...
Well, to clarify, there was a group of liberal judges who decided to file an amicus brief to the court, and the judge has accepted to receive the amicus brief in order that
They can make the argument that, no, this is wrong, you should prosecute.
Yeah, he has to be prosecuted, yeah.
Yeah. Now what's ironic about that? I mean, just think of the practical matter here. If the U.S. Attorney General, the District Attorney General, doesn't show up at trial to prosecute, how do you prosecute the case? So the judge says, I'm not going to dismiss it. Well, it's like playing a football game without one team showing up. How do you do it?
Yeah, if he's not dismissing, who's prosecuting Michael Flynn?
Yeah, that's right. If he's not going to prosecute,
is the
if he
judge going to prosecute Michael Flynn, and there'll be a judge and a defense attorney? I mean, how does this work? Yeah,
I can see this. So, Your Honor, I'd like to make this motion. Well, I don't know if I'm going to allow you to do that. Oh, please, Your Honor. Okay, well, you look nice to me. I'll let you. I mean, it's just ridiculous. Nuts. But here's the other thing. This is not appreciated. It has been lost, by and large, among our people and among our politicians. It's called the separation of powers. Judges judge, executive branch executes. And there's nothing by which you can force the executive branch, in this case, U.S. Attorney General, to prosecute. That's one branch telling the other branch what to do. Now, in Tennessee, for example, our Attorney General is appointed. He's his own constitutional officer, and he's appointed by the court, so he's not under the governor's authority. And even our state Supreme Court has said, we have no authority to make a DA prosecute anything. We can't. I mean, that's like telling the legislature you need to enact a same-sex marriage licensing statute. Well, I appreciate your thought, and I appreciate your opinion and your suggestion, but I'm not going to enact that law. And there's nothing a judge can do about it. I mean, it's the same thing with the education situation. Well, I'm not going to spend any more money. I'm just not going to raise more taxes to buy more things. So what's the judge going to do? He can't make the legislature pass a tax. He has no authority to pass a tax, collect it, and administer it. Distribute it is supposed to be done. I mean, we have rogue judges.
Yeah, I mean,
and this is a federal judge. He should be impeached. He should be removed from office.
Exactly. I mean, I think about, I just want to, just how ridiculous this is. If you take this federal judge in this Flynn case, if you take what he's doing to the furthest logical conclusion of the power he's assuming he has, what that would mean is you could just be a guy walking down the street. No one's accused you of, first of all, no one's accused you of anything. You've not been arrested. There's no one determining that you broke a law, and no one's bringing you to court. No one's prosecuting you. But a judge, in his infinite wisdom, has decided to go pluck you off the street, bring you into his court, and say, no, but I know no one's brought you before me, but I really think you should be prosecuted because I think you did this thing. So here we are. Yeah. I mean, that's exactly what the kind of power this judge is asserting. He's just judge, jury, prosecutor, everything. And that's just it. And he's like you say, he's a federal judge. How do we get here? I mean, how do we get here?
Yeah. And you know, it could be that this judge knows I'm going to have to dismiss. But what I can do is I can get these amicus people in here, and I can have a circus for a while, and I can keep stirring up the dust.
I can let CNN talk about it and get people all riled up.
And then I'll dismiss it.
Yeah.
You know, I'll eventually do it. But I'm hopeful. I saw something today that indicated maybe the Department of Justice would seek a mandamus order from the District Court of Appeals, which is the judges above him, right? And apparently that had happened in the past, and this very same circuit did the very same thing in a very similar case. They just said, you can't do this. Dismiss this case. I'm ordering you to dismiss the case. And again, I hope that will happen. And then the third case that was just of interest, and man, we could talk on this one for a long time, in my opinion, but I've got some friends that are litigating this transgendered athletes lawsuit that's been filed in Connecticut. I mean, it's a big case where they're representing some females, biological females. I shouldn't even have to use the word biological female, but biological
cisgendered females.
Yeah, that's right. They're cisgendered. Their gender and their biology join up, and they're tired of losing to these
to men,
males. Yeah, to men who identify as women, and they're running and they're winning and breaking all the school records and state records and all that stuff. And so they've sued and saying that's discrimination. It's unfair. And so the lawsuit is on behalf of these female students against the school system. I don't know if it's the state or the school system.
It's in Connecticut,
I think it's
right?
The state. Yeah, it's in Connecticut, and these male athletes who identify as women want to intervene in the case. And they want to make the argument that, no, I really am as female as those other females, and I should be allowed to run in this race. So the lawyers for the biological females, there are lawyers from the Alliance Defending Freedom Organization, ADF, they were referring to the interveners, who are the people running and winning all the races. They wanted to refer to them as males because they are males. Their genetic chromosomes, their biology is male.
Trying to distinguish between the plaintiffs and the defendants, so essentially.
That's right. Yeah. That's right. And the court said, well, I know you want to do that, but I'm not going to let that's against court decorum. It's unnecessarily provocative. It doesn't undermine your legitimate interest. It's not bullying to tell you need to refer to them as transgendered females. You can't refer to them as males because that's bullying and that's unnecessarily provocative. Now, in our crazy world, and I'll even say within the larger Christian community that always wants to be nice, doesn't want to offend anybody, we would say, well, sure, yeah, I mean, and in certain instances, you should, depending on what you're doing. But here we're in a court of law arguing a legal point.
Right. That's the difference.
Is there such a thing as a male and a female? Do bodies, physiology, anatomical, anatomy, does it matter? Is it real?
Is it relevant in this case?
Is it relevant? Or are there now 3 or 4 kinds of things called males, females, transgendered males, transgendered females, and then I don't know what else we'll next have after that. I don't know why we have to limit it to male and female and transgendered versions of them, because there are certainly people who think they're pangendered and transgender. I don't know what all they think they are, but I think, doesn't Facebook have 50 genders or 100 genders or something on it now that you can pick? Yeah. So I don't know why we're going to stop with male and female versions of this, but in other words, what people need to appreciate, and I had a friend write an article on this, that words matter. And I actually wrote a commentary that's published today. There's a story in Looking Through the Looking Glass about, Alice in Wonderland and Humpty Dumpty, and they meet. And Humpty Dumpty uses the word glory, and the question is, well, what does that mean? He says, well, it means this. And I don't remember what it was he said. She said, well, that's not what it means. And he said, well, it means whatever I say it means. And that's what I say it means. And then he makes the statement that the real question here is who is going to be master. You see, when I controlled the language and the meaning of words, I am in control. Mm-hmm. Because words convey ideas and beliefs and values. The community makes up words. I hate to use the word makes up words, but we come up with words to describe what we perceive to be a reality. Okay? And so words have an etymology that's rooted in older meanings of the word. So when we talk about autonomous, everybody says, well, I know what autonomous is, but it actually comes from the Greek auto, self, nomos, law. So it's self-law. That means autonomous. So there's a meaning and a history to words. And when you can change the word's meaning and history, then you change everything associated with it, which is why we had the bill I mentioned at the top of the podcast. The words mother, father, husband, and wife will have their ordinary meaning. We don't want some judge saying, no, they're all interchangeable words. Gary can be a mother, a man could be a mother, a woman can be a husband. It just really doesn't matter. And that's what they're fighting over in that case. And see, what's happened is the judge has already indicated what he really believes.
Right. Yeah, he's pushing his own ideology is what he's doing.
Yeah. Yeah. And because he now has that worldview defines what's dignity and what's decorum and what's bullying.
Right.
So to all of our good Christian friends out here who just don't want to get involved in all these things, and let's be nice and let's, whatever his name was, Rodney Phillips or Rodney whatever from years ago, that says, can't we just all get along and let's just be nice and whatever.
Rodney
King. Okay. You will soon be made to care, and you will be made to use those words, because otherwise it is impolitic. It is not appropriate judicial decorum.
Right.
It is bullying.
And in the court of law also, it's compelled speech. It's similar to the case we talked about in Dallas
last week,
where this business owner, it wasn't about necessarily her breaking the law. It was that the judge wanted of her to have a certain viewpoint and went so far as to want an act of contrition from her, an apology.
That's right.
It's just.
And see, this one, in this case, with the transgendered case, this isn't asking for an apology. He's essentially saying this is rude. This is not civil,
right?
To use the word male and female. And so I'm not really compelling your speech. I'm just asking you to be nice.
What I believe to be nice, yeah.
What I believe to be nice, because male and female really don't matter. Bodies don't matter. And it's what you think in your head you are. But what's interesting is, if what you think in your head is what matters, why is it necessary that I begin to try to conform my body so that it looks like something else? That seems inconsistent to me. If you think you're a woman, Gary, you're a woman. Why should you have to shave your beard and take hormones? I mean, you're sort of saying it's in your head, but it needs to kind of look like it shows in your body too. Well, why? If bodies don't matter. If bodies do matter.
That's because they do. Yeah.
They do. Yeah. We suppress the truth in our unrighteousness.
Yeah.
It's just terrible.
I hope everyone, listening I had some issues this week with, we won't get into it, but just, the whole Ahmaud Arbery thing, and having some conversations with my friends on Facebook back and forth over this. And there, the thing is, there are issues I feel like, and my frustrations about this, there are issues I feel like that the church takes an interest in, primarily I think because it's culturally acceptable to. So the things that get us clicks on social media and make us look cool and whatever, the church seems to have no problem getting involved in those issues. But when it comes to things like this, LGBT issues, transgender, and all these sorts of cases where really the impact of what courts do in these decisions are going to have far-reaching implications in our families and our children, and laws concerning our ability to parent. You've brought that up several times. People call you crazy for it, but the idea that as this ideology continues, at some point you're going to need permission from the government just to be a biological parent, because the government's going to have so insert itself into family dynamics that just simply biologically having a child is not enough for you to call yourself their parent anymore.
That's right.
But the church needs to be concerned about these issues, and I could be wrong. As I see it from my perspective, they just aren't. Like you say, I think they've been so convinced that to love Jesus, you just need to make everybody feel good and not offend anybody. And we don't want to be unloving and intolerant, of course. And so we've convinced ourselves that these things just are not within our sphere of influence, or a cause for us to take up arms. But, it's got to change. We got to start caring.
I have a friend who's not a Christian. And he said to me one day, we were driving somewhere together, and he said, the problem with you Christians. And I said, what? He said, you've changed the gospel of Christ for the gospel of nice. and the gospel of Christ is not nice. I mean, I hate to say it.
Yeah.
It was very pointed. It was very clear. People don't kill you because you're not pressing them on things they don't want to be pressed about.
Yeah.
And so,
telling someone that they're
it's not a call to be mean,
Mm-hmm.
but it is a call to be truthful. It is a call to be respectful, but to be truthful and to say to the judge, and they've done this, you have already indicated your bias. you've already indicated that you do not accept our basic premise that men and women are different, males and females are different, and we want you to recuse yourself.
Yeah.
It'll be interesting to see what happens.
We'll keep an eye on it. Well, David, again, good to chat with you.
It's good.
And as always, if you're watching the video, by the way, this podcast is on Apple Podcasts, Spotify, and basically anywhere there's podcasts. But if you can also find this podcast on video on our YouTube channel, and if you go to youtube.com/FactTennessee, FAC Tennessee, every episode we're also doing video. And so if you're watching the video, you can see underneath me here, we've got this email address, info@factn.org. It's info@factn.org. We'd love to hear from you and just hear your feedback. And we'd love for you to post questions too, because we'd love to answer those. And so please subscribe, join us wherever you listen to podcasts, and see you next episode.
If you enjoyed this episode, don't forget to subscribe. And if you want to help spread the word, please give us a 5-star review and tell your friends to subscribe too. We're available on Apple Podcasts, Spotify, and wherever you listen to podcasts. God, Law, and Liberty is a podcast of the Family Action Council of Tennessee. We are a 100% supporter-funded nonprofit advocating for family, life, marriage, and religious liberty. For more information, please visit us at www.facttennessee.org. That's FACTennessee.org. And please follow us on Facebook, Twitter, and Instagram @FactTennessee.